Saya Iman Prihandono, Dekan pada Fakultas Hukum Universitas Airlangga. Fakultas Hukum Universitas Airlangga ini adalah salah satu fakultas hukum yang tertua di Indonesia. Kami sudah berdiri sejak tahun 1952, bergabung bersama dengan Universitas Airlangga di tahun 1950, yang saat ini dijalankan di Fakultas Hukum Universitas Airlangga. Yang pertama, program studi S1 Ilmu Hukum. Yang kedua, program studi Magister Ilmu Hukum. Yang ketiga, program Magister Kenotariatan. Dan yang keempat adalah program studi Doktor Ilmu Hukum untuk S3-nya. Saat ini, Fakultas Hukum Universitas Airlangga memiliki beberapa akreditasi, baik nasional maupun internasional. Di akreditasi nasional kita punya akreditasi unggul untuk program studi S1 dari BAN PT, sedangkan di akreditasi internasionalnya kami terakreditasi oleh AUN (ASEAN University Network), lalu juga ada akreditasi FIBA-A, dan kami juga tergabung dalam Asosiasi Fakultas Hukum Dunia. Untuk ranking, Fakultas Hukum Universitas Airlangga di tahun 2021 menempati ranking 250-300 oleh QS World University Ranking. Tidak hanya itu, dalam ranking Times Higher Education, kami juga menempati ranking 201 dunia.
UNAIR merupakan salah satu fakultas hukum terbaik yang terdapat di Indonesia, dan bisa dilihat dari alumni-alumni di luar sana, memang banyak yang menjadi praktisi hukum maupun ahli hukum yang berkompeten di bidangnya.
Setelah masuk Fakultas Hukum, saya mendapatkan segala hal yang sudah saya ekspektasikan sebelumnya, yaitu pembelajaran menggunakan bahasa Inggris, pembelajaran yang juga mengutamakan soft skill dalam artian debate dan discussion, lalu yang ketiga, sistem pembelajaran dua arah yang sangat aktif antara dosen dan mahasiswa.
Di Fakultas Hukum Universitas Airlangga memiliki koleksi buku yang lengkap, kemudian ruang baca yang nyaman bagi mahasiswa untuk bisa mendapatkan berbagai literatur dan referensi untuk menulis tugas ataupun karya ilmiahnya.
Saya banyak mendapatkan ilmu-ilmu bukan hanya ilmu-ilmu teoritis, tapi juga ilmu-ilmu praktik.
Saya sangat tidak menyesal karena banyak sekali ilmu yang saya dapatkan, dan juga dosen-dosennya sangat kredibilitasnya tinggi. Oleh karena itu, di sini saya mendapatkan pengalaman yang terbaik.
Nah, itu sekilas gambaran tentang Fakultas Hukum Universitas Airlangga. Sampai jumpa di Eva UNAIR.
UNAIR hebat.
UNAIR hebat.
UNAIR hebat, Eva best.
Eva best.
Wabarakatuh. Selamat pagi Bapak Ibu sekalian, rekan-rekan Fakultas Hukum UNAIR. Hari ini di depan saya ada Profesor Master in Rechten, Dr. in Rechten, Joost. Yeah. So Pak Joost, how are you today?
I'm all right.
Okay.
Pleasure to be here.
Thank you Pak Joost. So hari ini, today, we're gonna discuss about the update on corporate criminal responsibility in Indonesia and in the Netherlands. So Bapak Ibu sekalian, hari ini kita akan membahas mengenai update atau perkembangan berkaitan dengan tanggung jawab pidana di konteks korporasi, baik di Indonesia dan juga di Belanda atau di Netherlands. So Pak Josnan, give us some information about corporate responsibility in Netherlands.
All right, thank you. That's a good question because our system is a little different from the Indonesian system. Because we only have one stipulation on the corporate liability of legal persons. And it's in our main criminal code, Wetboek van Strafrecht.
Wetboek van Strafrecht.
And as I understand it from the research of Dr. Maradona, in Indonesia, every separate law has its separate stipulations on liability of legal persons and maybe also on natural persons involved in the conduct of the legal person. With us, everything is put in Article 51 of the General Code. And that means that works for all crimes possible.
All crimes?
All crimes, even outside the regular code. So we have a law on economic crimes, we have a law on drug crimes, we have a law on even traffic crimes.
Even traffic crimes?
Everything. Also, a legal person, in theory, could commit any crime possible. There's a few exceptions. If they don't have the status needed for the crime, such as when you're not doing your duty as a civil servant, that is impossible for a legal person to perpetrate. But he can co-perpetrate this crime with a civil servant, for instance. So the liability is very easy and very wide because it's through Article 51. It is for all crimes you can think of.
So how to determine whether it is the liability for a legal person or natural person in Netherlands?
Well,
do you have any standard or something?
No, there's no general rule. Well, except for that, in principle, a legal person can commit any crime possible.
Any crime,
except for certain exceptions, which make sense because of the type of crime that is involved.
So, tell me about the exception of the crimes that cannot be possible for a legal person to be conduct.
I think one of the ones we already discussed, the civil servant who is not doing his job, maybe taking a bribe, because a legal person is never a civil servant. He is the legal person cannot commit that crime. That is impossible. I'm thinking of another example.
Murder.
So I think a company could commit
such kind of crime.
Yes.
Oh yeah. Is there any cases that?
No, I mean, of course, usually legal persons commit economic crimes, fraud, those kinds of crimes.
Bribery, some things,
Especially also bribery, yes. In the Netherlands and outside of the Netherlands, when they're doing business in other countries. But I think it's generally thought that company could even commit a physical act like manslaughter or murder.
Is there any special case or landmark cases that you can tell me about such kind of murder crime?
No, there's no real examples of that. But we do have a general ruling of the Supreme Court on the criteria to hold a legal person responsible for the acts of natural persons. That's a case from 2003. But if you take those criteria, it could be perceivable that a company also commits murder. If it's in the interest of the company, if the company had the power to do it or prevent it, then it could be. So, for instance, I'm just making this up because there's no real case on this. I'm just making this up. There's a company. And there's a rival company and the director of that other company. If the one company orders the other company's director to be killed
by the company,
be a hitman, then you could think that the legal person is responsible for that crime. If the directors of the one company order the murder of the other one on behalf of
the company,
of the companies, because not of personal reasons, but because of business reasons, I would say that also the company, the legal person, can commit murder.
So tell me about
order
or order murder. Yeah. So tell me about the criteria, those criteria that you told me about, how we relate one crime with the company responsibility.
The general criterion is could the acts of natural persons, like the director, employees, advisors, if what they do can be reasonably attributed to the legal person.
Okay, one.
And
then?
that happens if, usually, says the Supreme Court, if the acts that happen are within the sphere of the company.
Oh.
And that means, usually, if the company can order the acts, allowed for the acts to happen, if it was allowed.
Is it possible to for the company to allow someone to murder hire a hitman to murder someone?
Of course, it's against the law.
Of course.
But if the directors and employees of the legal person, if they're okay with this, and maybe pay even with company money, and it benefits the company.
It benefits the company.
Then, although the difficult part is, of course, legal persons usually are not started to murder people. Businesses are started to do business.
Yeah.
So it would be a little more difficult. To link murder with a legal person, but it could be possible.
How to prove it?
That can be by any witness and expert, camera, any evidence. Could prove it, as long as a clear link is established between the acts of natural persons and the legal persons. And if it benefited the legal person, if the legal person through its directors ordered the act, or allowed the act to happen, then it is thinkable that even murder can be committed by a legal person. But there's no evidence that this ever happened. I don't know of any case. And usually, like I said, it's environmental laws they break, business laws they break, competition laws, economic crimes, fraud, bribery. That's what companies are usually accused of. But for instance, if you start a company and you start to manufacture drugs illegally,
so
that could also be.
This kind of company, is it possible to access in Netherlands? This kind of company?
Well, if you start a company to break the law, then
it's impossible.
Then, of course, technically that's not allowed. And you will also usually have a criminal organization. Because you really want to break the law.
So,
but if, let's say, pharmacy, apotheek, is a legal person. And they produce legal drugs. But they also sell illegal drugs. Then the apotheek, the company itself, could break the drug laws. And we have not discussed the natural persons, but the natural persons involved in the Dutch system are usually also liable.
Okay. So, Pak Joosnan, can I call you Pak?
Sure.
Yeah.
I don't know what it means, but
Pak is sir.
It sounds nice. It sounds nice. No, you can just call me Joost.
I mean,
my mother does, so.
Yeah, your mother. For me, it's better for me to call you Pak.
Okay, well, it's not necessary. We know each other, but all right.
Pak Joosnan, what is the criteria of company in Netherlands? I mean, the definition of company.
Yes, we start with the civil law definition.
Civil law definition.
Of a legal company. So any limited company, de BV, de besloten vennootschap, het naamloze vennootschap, those foundations, those are legal persons.
Legal persons.
But also smaller, more special civil law vehicles, like when two people act together.
Yeah. You can call it corporate or company.
Yeah, it's not a legal person by civil law.
Yeah.
But it is, I think, a company by criminal law.
So by
and also the shipping yard.
Shipping yard.
People who has boats. That's also technically not a legal person by civil law, but in criminal law, it's called a legal person anyway.
Okay.
So it's a broader definition than just the civil law definition. It's here. Yes, vennootschap zonder rechtspersoonlijkheid. That's when you and I have a company together without any legal status.
Yeah.
That's one. And the rederij, for instance, that's the shipping yard.
The shipping yard.
That's also you can for criminal law. That's called a legal person. So it's wider than the civil law definition.
So in Netherlands, you are using the broader definition of corporate, yeah.
Yes.
Both legal corporate or non-legal, not illegal.
They're not legal,
it's not legal,
by
but
civil
by civil law, yeah.
Because in civil law, you start a legal company to escape liability as a natural person in case something goes wrong.
Yeah.
And for criminal law, we said, well, those types of organizations should not, if you participate in that, the organization itself should not escape criminal liability.
So if there are a couple of persons, they have some similar goals, can you call it corporate?
If they work together.
They work together?
It would be called a legal person for criminal law standards.
But not for the civil law standard. Yeah?
Not always for civil law.
Okay. So, Pak Joost, you told me about the case that happened in 2003. Yeah. So, can you tell me about that case?
Well, in that case, it's a landmark case.
Landmark case, yeah.
It's where manure, farmers,
yes,
their cows and their animals, they produce manure.
Yeah, manure.
Yeah. And there's rules to get rid of that manure.
Oh yeah.
Because if it's a lot of manure, that's bad for the soil. It's bad for the environment.
Manure. What is manure?
It's when cows poop.
Oh, cows dung, yeah. Okay.
I hate to say this online.
It's okay.
That's I thought. So, and from other animals.
Yeah.
That has to be handled.
Careful.
You cannot just throw that away.
Yeah.
Because it's bad for the soil. It's bad for the water.
Yep.
It's in general bad for the environment.
Yeah.
And the farmer was accused of breaking the rules.
Environmental law.
Yes, because it costs money.
It costs money. Okay.
And you can only have that much manure without you having to ship it somewhere else.
Okay.
And that costs money, of course. And if you cheat on the numbers, on how much manure you have,
yeah.
So, and then the Supreme Court gave the general criteria to hold a legal person criminally liable for the acts of natural persons.
Okay.
It has to be in the sphere of the legal company. And one of the criteria is also if it happened in the regular business of the company. Then it's easier than if you do something outside of the regular business of the company. And that's what's the problem with murder.
Maybe.
Because a legal person its business is usually doing business, not committing murder.
Okay.
But for instance, if you have an industry making and producing anything and causing, of course, pollution.
Pollution, yeah.
Yes. And there are limits to that pollution. You have a permit.
Yeah.
If you break the permit because you too much gases or too much water, that's not good anymore. it's usually a crime.
Okay.
So, and if the company pollutes more than the permit allows,
Yeah.
it's reasonable to say, well, then the company committed the crime.
Okay. So since when the Netherlands law having kind of concept of corporate criminal liability?
We started in 1950 with the Act on Economic Crimes, Wet Economische Delicten.
Yeah.
And
Wet op de economische delicten, yeah.
And in Article 15, the liability of legal persons was introduced in our system. And in 1976, we transferred it from the economic crimes to the regular Wetboek van Strafrecht. And now it means that a company can commit virtually any crime.
Oh, okay.
And next to the company, the natural persons involved acting, furthering the crime can also, or ordering the crime can also be held liable, even if they don't physically do anything concerning the crime itself. So if I'm the director of the company, my company is a legal person, and I order people to pollute more than is possible, allowed for the permit, for instance, then the company could be held liable. But I myself
can also be held liable
for and also through the acts of the legal person. So I'm not polluting myself, of course. I'm sitting at my desk doing
of course.
Outside is where the pollution, where the crime is happening. Even if I'm not physically involved, I am held liable because the company is liable and I had leadership of the company over this crime. And it doesn't need to be an official leadership.
It doesn't.
It does not.
Oh. No. Is there any kind of position that can be held liability for corporate liability?
Well, it's of course if you are a director or an advisor, if you have a formal position it's easier to hold you liable. But even if you are formally outside of the company, you could still be in leadership of the crime. For instance, if I'm an advisor. Yes, and I have a powerful position outside of the company, but people listen to what I say. And I come in once a week on Monday and I give advice on what to do.
Is it such kind of beneficial owner?
No, it's even wider. It's because if it was only for people with an official position within the company, then people would, make sure that they don't have an official position. And but still own the company or still run the company. But under someone else's name. And to prevent that, we have very wide criminal liability for natural persons. So even if they don't have a formal position within the company, but they do act within the company.
Controlling the company.
Yes, but not officially.
Even it's not officially.
If it's not on paper, then they could still.
Give me an example for that.
Well, like if I'm an advisor to the company.
Advisor, is it non-formal?
Maybe. If I don't have, I'm not an employer of the company. I'm not a director of the company. I'm not a shareholder of the company. I'm not the beneficial owner of the company.
But you're hired by the company.
I am hired by the company to give advice. And I give advice in such a way that the company commits the crime. Then I could be in leadership of that crime.
I see.
And the company is also committing the crime. Because it benefited the crime. It benefited. And the company knows about it, but does nothing to stop it. If you do it the fourth time, the company is also liable.
So if there is a company committing a crime, What kind of criminal penalty for the company in Netherlands?
Well, technically, all crimes, all penalties. But of course, you cannot.
All kind of penalties.
But you cannot send a legal person to jail. That's impossible. So usually it's a fine.
Fine. Okay.
Yes, but it could be a very high fine.
What is the most severe penalties for the company in Netherlands?
That's good.
Yeah.
I have that with me. I think it's up to 1 million for each crime.
Only fine? Or we can close the company permanently?
Well, if it's an economic crime, you can close the company down.
Oh.
And I have to say this very carefully. It could also be that the fine is up to 10% of the yearly revenue.
10%?
Yes.
Is it big enough to give such kind of redemption to the company?
Well, if it's a big company, then 10%. Well, for a small company, 10% is the same, but still, it could be millions, maybe even billions.
10%.
You know, if you do that 10 times.
100%. For the revenue,
you lose all your money for that year. So you make
only that year.
Well, if you make another, if you commit another crime, depending on what crime it is, it could be another 10%.
Is it cumulative or alternative?
The fine is cumulative.
Cumulative. So if we do kind of such crime in several years, so each year will be cut 10%.
It could be a very large fine, yes.
Very large fine. So is it effective in the Netherlands?
Oh, that's always difficult to say, and we'd like to think that if it's forbidden, if it's in the criminal law, people don't do it. But of course, people break the law all the time, and so I don't know if there's really numbers on how effective corporate liability is. What I do know is that most of the crimes committed by corporations are not really intentional.
Not really intentional?
Yeah, well, maybe, I mean, they broke the rules, but I didn't, the company didn't know all the rules. Or stuff happens more or less by accident. It's, of course, sometimes corporations willfully do something wrong.
Of course.
But the evidence shows that a lot of times they were unaware of the specific rules. And, well, they did something wrong, but there was no real plan behind it. And if there's no real plan behind it, the criminal law, of course, cannot prevent it. Because the idea of you not committing a crime because it is a crime means you make a balance between what's the profit of the crime and what's the downside. What's the penalty? If the upside is bigger than the penalty, you commit the crime. But if the penalty is higher than your profit, you don't commit the crime. But for that to make that decision, you actually have to know it's a crime.
Of course, And
if you are just doing your business and you don't really know what the rules are, you don't really know that you're committing a crime.
But it is corporate. They have legal inside every corporate, I think.
But even, I hate to say this, but even lawyers make mistakes.
Of course. Many.
Well, many lawyers make some mistakes.
We are humans, though.
Me included. I am one of those many lawyers who make mistakes. But if it's a small company, and I mean, these are just the criminal law rules. It's very hard to know all the rules. And of course, also accidents happen. But to give you one example of where a company deliberately broke the rules, which is a big, we had 3 major banks in the Netherlands.
Oh, banks?
The ABN AMRO, the ING Bank, and the Rabobank.
Rabu bang. Rabu bang.
I just closed my account with Rabobank, not because they were breaking the law, but because I had no further use for that bank account. But you have money laundering rules. Of course.
Yeah, we have
Rules on preventing money laundering.
money laundering.
Yes. And that is a very big law in the Netherlands. And it says, for instance, that banks should check who their client is.
Oh yeah. Corporate due diligence for that.
Yes, yes. Banks have to check who their clients are, and they have to check if certain financial transactions are not actually money laundering transactions. Now, and all the banks did not have their check system in order. And sometimes,
including that bank,
including the big banks.
Yeah.
And sometimes only 3 transactions a day were checked out of all the hundreds of thousands.
No matter how much.
No matter what happened.
Oh.
So and that was the policy of the bank.
Oh.
And so those banks, when they found out they were not having their checks in order to prevent money laundering, the prosecutor made a deal with all 3 of them.
True. Okay.
And the ING bank had to pay in total a fine and other penalties of 775 million euros, which has to be a gazillion, billion, trillion rupees.
Yeah,
I'm correct.
Of course. A lot. Yeah,
Yes,
it's a
but
lot.
Also for Dutch standards, 700. I think 775 million. I don't have 75. I don't even have $1 million. Huh? So that was a big case where the banks deliberately broke the rules. And they also were held accountable for culpable money laundering.
Okay.
And because of the high sum they paid, there's now a new law in our parliament to have the judge check those kinds of settlements.
Okay.
Because the case was settled out of court.
Oh, out of court.
And the prosecutor said, if you pay me $775 million,
it's transaksi, right?
Yes, it's a transaction. You don't go to the judge. You don't go to court. And the banks all said, well, the other banks had a little lower transaction, but they said, all right, we'll pay you this money, and then we're clear, and we're changing our behavior. We're going to try to do our best. But of course, 775 million to end a lawsuit without a judge involved, which is, that's special. So now those kinds of transactions, if that law comes into effect, the judge has to agree with the settlement, with the transaction. And there's the ING case for the bank is done, but
those 2 banks, how about this?
There were 3 banks, and they all 3 had a transaction.
Okay.
And for one of them, actually for ABN as well, but this one's most interesting. The prosecutor said that all the natural persons within the bank were not at fault.
Not involved.
Not
even the director.
No. The company made the mistakes, and all the employers made small mistakes, but no natural person was
involved,
was criminally liable in his involvement.
Oh,
but then some people took that decision to court, and saying, well, we want the director of the bank, the president of the bank, who knew about this and allowed this to happen. We think he should be held criminally liable and he should be prosecuted. And then the court, I think a year or 2 ago, ordered the prosecutor to prosecute the director, the president of the bank, for the acts committed by the bank. Because he was the factual leader of those acts. Because as president, he knew the policy was lacking, it was not good enough. And he was warned that these violations were taking place, and he did nothing to prevent it.
Oh, I see.
And so that means that even he wasn't actively involved in the crimes, he was still passively negligent. And he should have done something. And the Supreme Court says that is also a way how you can lead the company into crimes is by not acting where you should have acted. Because you know things are wrong, and by not acting, you allow it to happen, and you accept it. And if the president of the company says, no, go on with your business, it's okay what you're doing, then you can be held accountable. But that case is not being tried yet.
Okay.
That's an ongoing case.
Okay.
Still.
So, but in your opinion, that will be the case for the director to be one of the convicted person in the
Well,
case?
I wrote this regarding the deal. Two interesting points on that deal, and one is a little technical, and maybe we should leave that out unless we have time. But the other one, I said, it's very hard to believe that the president cannot be held criminally liable. Because, like I said, he was warned. It happened on a large scale. It wasn't just one incident where it went wrong. No, this was on a daily basis it went wrong. The director knew about it. And I said, the Supreme Court has this passive way of leading the company, which is written for this kind of situation. And so I said, there's a question mark there.
Of course.
Is good enough. And then later on, other people, I'm not saying I caused it, not at all.
Something fishy about that deal. Interesting.
And I think, luckily, other people took that case to court and said the director should be prosecuted.
So it's really interesting. But now we have Pak Dona here. He's gonna tell us about the corporate liability in Indonesia, corporate crime liability in Indonesia. So, time and place is yours.
The floor is yours.
Yeah. Thank you, Pak Iqbal. But I think it's more interesting if we can elaborate more in the perspective of.
But we have two speakers here today.
We have two moderators today. And speakers.
It's two against one now.
I just want to elaborate more about that ING and Rabobank case.
Rabobank.
And also the ABN.
And the ABN AMRO,
enough, the former presidents of the ABN Bank, they are under criminal investigation already.
Currently,
even without the court ordering them. So the prosecutor learned from the decision by
of Rabobank,
in the ING case, especially.
But there is significant differences between transaction system with the deferred prosecution agreement in UK, for example, because in transaction, it's not talk about the what you call it, the guilt, right?
Guilt.
Because,
you don't have to officially say you did something wrong.
We conflict guilty, if the bank
you're not convicted,
and
it's also the prosecutor is also not saying. He thinks you are guilty, but he is not. That's by law. Although, I have one more thing to say about especially the ING case. There was a report by the public prosecutor about a public report, 25 pages, on their private or their investigation. And they actually in the report said, well, we hold the ING bank liable, criminally liable for these crimes. So, but in a transaction, formally, the accused is not convicted. He is not said to have committed the crimes, and he is not saying he committed. You don't have to, you buy your way out of court, but you're not formally guilty.
Not formally guilty.
You don't have to state. Well, for this deal, the bank said, okay, we did something wrong, but for a transaction, normally, you don't have to accept that you're guilty.
I think that's the major differences between the DPA, Deferred Prosecution Agreement, in the UK, because they make a confession and then they will settle out of the court. That's different within the Dutch in the.
Well, that's also a new development in Dutch criminals. The Dutch criminal system is when a case is in court, the prosecutor and the defense can still make a deal. And then the judge has to agree with that deal. And that is something that could also be done with legal persons. Because if a case is in court and let's say it's maybe 100 or 200 crimes that the company is accused of, and the dossier is how many pages. It's all on it's in the cloud, of course, but I mean, if there's 200,000-300,000 documents, you have 100 witnesses, 25 expert witnesses. If you have that in court, it will take years.
Yeah, of course. Yeah.
It will cost the prosecutor money. It will cost the taxpayer money. It will cost the courts.
Of course.
All these judges that cannot try other
Cases.
crimes. And of course, it will cost the bank a lot of money because they have to pay all these fancy lawyers.
Yeah.
Well, if the bank calls me, who am I not to help them?
You're a fancy lawyer.
You know, if they're willing to pay $775 million, maybe they're just a little bit of that.
Yeah,
that's okay. So I think we will see in the future that besides the transaction and the court agreed upon sanction of the transaction, we will also see cases that are already in court with legal persons. Also, they make a deal and the judge says, okay, I agree with this deal. You are guilty and this will be your penalty.
Okay, Pak Duna. Can you tell us about
I don't know what I can say about in our system. Professor has already know, right, about
well,
the system
let me
in
just
Indonesia.
ask you, what is the advantage and the disadvantage of having corporate liability for every specific law instead of what we have? One general system where you have one stipulation which applies to virtually all.
So now we have two moderators and one speaker.
That's a good question. Because fortunately, that's the way our legal drafter choose to implement the system of corporate liability. And even if we have the new criminal code, that problem still exists because there is no transition stipulation compared to that in 1976, right?
Yes.
When they have decision to just annul the regulation within the wet of economic delicted and then just go to the Article 51. And then in our draft of criminal code, there is no transition stipulation stipulate that all regulations related to corporate criminality outside the criminal code actually should or must follow the system in our criminal code. But there is no I've said to the my colleague, the drafter of the KUHP, and I asked him to just put the transition stipulation on that criminal code. If not, we will stay the same system. All regulation outside criminal code has their own stipulation, and we have one more regulation in our criminal code, general code. So there will be nothing. Just put another. Just put another problem to our system. So that's our future problem if there is no transition stipulation. Secondly, in my opinion, in our draft of criminal code, they try to what you call it. Now we have the broad definition of corporation in our several stipulation. But now they try to shrink it over, and in my opinion, there will be the legal drafter try to exclude the public corporation as one of the subjects.
Well, that's an interesting topic.
Yeah, because now there is my another research after my dissertation under your supervision. We talk about the public corporation, and I don't know, this is systematically political move or not, because now we are streaming. Because they try to exclude the public prosecution with that definition.
Yes.
For example, now in anti-criminal law, for example, the public corporation can be the part of the criminal law subject, but with the definition of our draft of criminal code, this entity, they are excluded. Yeah, I don't know why they choose to make this one. But secondly, I think maybe later we can write paper together related to the functional offendership, because in the perspective of our criminal code right now, they also focus not only to the corporation itself, but someone who has the functional function,
actioning behind the scenes.
Yes. Indeed, we have the stipulation in our criminal code related to opdrachtgever, vertellinggever, but in our system there is still confusion what actually they mean about someone who actually lead the misconduct and then actually behind misconduct. As you already mentioned in one of our class last week, I think that if you try, this is corporation, if you try to prosecute the natural person with the corporation, you must prove that this natural person
did something wrong.
Did something wrong first. You cannot directly go to the natural person because you
could, but that's a different liability.
That's right. Because in my opinion, if I have discussion with others people, they see that actually similar, even though the similarity is a natural person. But if it's in the context of natural person, we should go to the corporation first and then go to the natural person. We cannot go directly to the natural person because it's different, right? This is the functional offender of the corporation. In the other side, this natural person can act individually as a natural person. So I think it will be good topic if we talk about the origin of the functional status hub and the development, the origin. I think in Article 50A, right? In 1950s, in your wetboeken strafrecht about the functional status hub.
Well, I think it was on natural persons and legal persons. Yes. But we always said that even if you don't commit the crime physically yourself, you can be held liable as the functional, as the one behind the scenes for the crime that is committed. If it was in your power that the act was committed and you accept it, or previously you have accepted similar behavior. For instance, I am the farmer. I milk the cows. You sell my milk. You're my employee. I'm not a company, but I'm a simple farmer. Is selling the bread. Even if he is at the bakery and the sale is somewhere else, if there's something wrong with the bread, maybe it's poisonous or he breaks the rules. And that's what functional daderschap, perpetratorship means. It was in your power that the act was committed and you accepted that it was committed. And by that reasoning, sometimes you don't need the legal person, because if you have a legal person, but you have someone outside of it without a formal relationship to the company, but it technically is his company because, basically, factually it is. So he is selling or breaking the laws through the company. You could also say, well, we just take the company out of the equation and we see that the act is committed by someone behind the company or through the company. And then you have two ways of liability. One is factual leadership. You say the company did something wrong and the one giving factual leadership to that offense did something wrong. But you could also say, well, that natural person just committed the crime through the legal person or anyone else.
So, but just which one do you think better? Regulating about criminal, corporate criminal responsibility in the criminal general law rules, or regulating criminal responsibility or corporate outside the criminal general laws? Which one is better?
The advantage of our system is the simplicity of it.
Simplicity of it.
It is so simple because you look at one stipulation.
Yeah.
One of the downsides is it's not very elaborate. So you need the Supreme Court's ruling to understand what it actually means. And there's one on the liability of the company, and there's one general landmark case on the liability of natural persons as factual leaders.
Yeah.
And I think the Indonesian system, its disadvantage is that for all these different crimes, you have different rules on liability. But the positive thing about it is that depending on what type of crime, you can specialize the liability. And for us to do that, it would take the Supreme Court maybe to specialize it a little bit. And that makes it less predictable. And then in the Indonesian system, depending on the type of crime, you know exactly how the liability is written in the law. And with us, because we have this broad stipulation, which is not very detailed, it's less predictable. So you're not sure if you are liable or not. You need a lawyer to tell you.
Yeah.
Fancy lawyer, yeah?
Yeah, sometimes. Or me.
Yeah. I think now in Indonesia, we have, I think the positive trend in the number of cases related to corporation as the subject of punishment. Yeah. Especially in the environmental crimes. But one of the problem will be because if for the corporation only impose for the primary sanction, I think it's not enough. Because if we talk about the environmental case, actually it's involved the huge loss of the environment, the society. And then now the prosecutor, the trend of the Indonesian prosecutor right now, if they deal with the environmental case, they put a secondary punishment, not only the primary punishment, but the secondary punishment related to the, I think, a rehabilitation cost, and then so they ask the judge to put additional decision related to how much money that actually the corporation should spend to the lying the decision to the Supreme Court to make interpretation, to make the criteria. But here in Indonesia, we look at the regulation, we look at the law. There is no regulation, there is no stipulation, there is no detailed stipulation related, especially
so
in the context of procedural law, for example. If actually there is one case in Sumatra that the judge actually already imposed like I think it's huge money for the corporation to be compensated to the victim. But the prosecutor, as the executor of the decision, is still confused with how we can implement this money because there is no.
How you can collect.
Because there is no stipulation related of the execution. So that's now become the problem because again in our system we really hardly rely on the stipulation step by step and etc. And that's how this become the problem.
But the Dutch Supreme Court always looks at the law first, of course. But if the law is silent on the details,
and the judge
then the Supreme Court has to fill in the further regulations. But I think we have a system that usually works and it's used quite often, especially for environmental crimes, economic crimes, and companies get prosecuted all the time, and also for tax crimes, evading taxes, and sometimes also the natural persons are prosecuted for the wrongdoings. And there's also one extra way a natural person can be criminally liable. If I, for instance, if I forge a document for the company, and maybe the company commits the crime, If I'm the director doing the forgery, I could also be held liable as the factual leader, but I am also myself forging the documents. So you don't need all the legal persons and factual liability because you also conducted the crime yourself.
Yeah.
So that's the third way to hold people, natural persons, liable, even if they do something in the sphere, in the scope of the legal person.
Okay.
And then my last, actually this is questions and also a statement maybe, because if we talk about the criteria to establish the actus reus of corporation, the reasonable attribution, right? There is a criteria. You mentioned that there's actually alternative, right?
The concrete criteria are
actually alternative, right?
Alternatives. Yes.
And now, this is some of the perspective of our scholar here. There is a cumulative because it's involved against the profit for the corporation. That will be the top point of the criteria. So one scholar said that if there is no single profit saved by the corporation, so why you must punish the corporation? Yeah. So against that will be the what you call it? It's very substantive criteria for the corporation related to the profit accepted by the corporation. So when in the Netherlands there is a reasonable attribution criteria, it's actually alternative. Why how we establish the corporate criminal liability just by the conduct of, for example, one of the directing men of corporation, even though there is no profit accepted, and then there is no power of accepted and prevention or acceptance and prevention criteria. So how you give an argument that's alternative, not cumulative?
Well, the Supreme Court is very afraid, of course, that if all the four criteria they mentioned, if all four have to be there for every case, then if one of the four is missing, then a legal person could not be held liable. That's why they rely on the general criterion of the reasonable attribution. And they say that is usually the case when it happens, the offense happens in the sphere of the company. And to establish that, you have four criteria. Was it in the regular conduct of the company? Was it in the power of the company? The act happened or not? Was it accepted? And was it profitable? Was it profitable?
So actually the criteria only the reasonable attribution, whether the misconduct committed within the scope of corporation.
Yes.
Since we have viewers here, so and we have Zoom here. Is there any question from our viewers, both from Zoom or YouTube? Not yet.
I'd like to say that you talked about the liability of public legal persons. That is not an easy subject in the Netherlands as well, because our central government cannot be held liable. Only the lower branches of government can be held liable.
Ministry can be held responsible?
Yes. If they are, I don't know if they are legal persons though.
Are they?
So the minister has its own I don't think that the ministry is a separate legal person, but the province or a city.
Oh, province and city. But ministry cannot.
I don't think the ministry is
responsible for that.
No, that's part of the central state.
Part of it.
They enjoy the immunity.
The lower branches of government have immunity if they are acting within their duties. So only if they do something that also regular persons could do. If they organize a party, for instance, you and I can organize a party. So if they break regulations organizing a party, they can be held criminally liable. But if, for instance, they are handing out driver licenses, that is something they should do because it's their public duty. Then if something goes wrong, they cannot be held criminally liable. But of course, the natural persons, the civil servants, maybe doing fraud with the driver, they are committing a separate crime.
Okay. Separate crime.
Separate crimes as civil servants.
Because of their position or because of their
because of the status as civil servants.
Okay.
If they commit crimes in their duties, the official branch of government is not held liable, but the natural persons are.
Okay.
But that's a very difficult topic.
Yeah.
We also needed Supreme Court rulings.
We will talk next year in the studio.
All right, I promise. I promise.
Oke, silakan yang lain mungkin kalau ada yang mau ditanyakan silakan. Ini ada Bu Amira Paripurna. Silakan Bu Amira. Tidak? Belum ada?
So, it's okay for us to put this video on YouTube, right? It's okay.
Yeah.
This is streaming on YouTube right now, and then we put it as YouTube. So this is recording session of our session.
I've told Pak Joost before.
Okay.
Yeah. So it's okay. Ada pertanyaan lagi silakan. Dari YouTube tidak ada? Dari Zoom? Kalau tidak ada mungkin nanti dibaca di subtitlenya. Oke. Terima kasih Pak Joost.
Subscribe and comment.
Subscribe and comment.
Please subscribe.
Fakultas Hukum UNAIR.
And like, right?
And like.
Thumbs up button?
Yeah.
I don't have a YouTube. I don't have Twitter or whatever.
Okay, thank you Pak Joost.
My pleasure.
Yeah,
Honor to be here.
Yeah, Pak Dona also. Thank you Pak for your time.
Pak Iqbal, mohon maaf
for your time. Yeah, for your information about corporate criminal liability in Netherlands and Indonesia. So thank you. See you again next time.
Thank you. Bye.